Madam President, members of the Court, in conclusion, I share with you two photographs. The first is of a whiteboard at a hospital in northern Gaza, one of the many Palestinian hospitals targeted, besieged and bombed by Israel over the course of the past 3 brutal months. The whiteboard is wiped clean of no longer possible surgical cases, leaving only a handwritten message by a Médecins Sans Frontières doctor which reads, "We did what we could. Remember us." The second photograph is of the same whiteboard after an Israeli strike on the hospital on the 21st of November that killed the author of the message, Dr. Mahmoud Abu Nujayla, along with 2 of his colleagues. Just over a month later, in a powerful sermon delivered from a church in Bethlehem on Christmas Day, the same day Israel had killed 250 Palestinians, including at least 86 people, many from the same family, massacred in a single strike on Maghazi refugee camp. Palestinian pastor Mundhir Ishaq addressed his congregation and the world, and he said, and I quote, "Gaza as we know it no longer exists. This is an annihilation. This is a genocide. We will rise. We will stand up again from the midst of destruction, as we have always done as Palestinians, though this is by far maybe the biggest blow we have received." But he said, "No apologies will be accepted after the genocide. What has been done has been done. I want you to look in the mirror and ask, where was I when Gaza was going through a genocide?" South Africa is here, before this court, in the Peace Palace. It has done what it could. It is doing what it can by initiating these proceedings, by seeking interim measures against itself as well as against Israel. South Africa now respectfully and humbly calls on this honourable court to do what is in its power to do, to indicate the provisional measures that are so urgently required to prevent further irreparable harm to the Palestinian people in Gaza, whose hopes, including for their very survival, are now vested in this court.
Madam President, members of the Court, I should like to thank you for your kind attention. I ask that you call Professor Lowe, KC, to the podium now to describe the provisional measures sought by South Africa on behalf of the Palestinian people.
I thank Ms. Negralik, and I now invite Professor Von Lowe to address the Court. You have the floor, Professor.
Madam President, members of the Court, it's a privilege to appear before you and an honour to do so on behalf of the Republic of South Africa. This case is brought under Article 9 of the Genocide Convention, which entitles any contracting party to the Convention to submit to the Court disputes relating to the interpretation, application or fulfilment of the Convention. The Court does not at this stage have to determine whether or not Israel has or has not acted contrary to its obligations under the Genocide Convention. That can only be done at the merits stage. It's concerned now only with the question of what provisional measures are required pending the Court's final decision on the merits. The Court's jurisprudence points to 5 requirements for the ordering of provisional measures. The first is that there should be prima facie jurisdiction, and that was addressed by Professor Dugard. The second is that there should be a link between the measures requested and the rights underlying the main claim. This requirement is plainly satisfied. The measures request an order that Israel does not violate the very rights secured by the Genocide Convention as set out in South Africa's application. The third is the plausibility of the rights that are claimed. Professor du Plessis explained that this is clearly satisfied. The rights claimed are the very core of the Convention, notably the right not to be killed or seriously harmed, and the right of the group not to be physically destroyed. Fourth and fifth, there must be a risk of irreparable prejudice capable of arising prior to the final determination of the dispute, and there must be urgency. Ms. Negroli addressed those points. Israel has, for over 3 months, been mounting a continuous siege and bombardment of Gaza of a ferocity and duration that can only be seen as an attempt to destroy Gaza and its citizens. And it is publicly asserting that it will continue to do so. You are aware of the scale of the death and the scale of the destruction, and it is continuing at this very minute. The court has said that, quote, a state's obligation to prevent genocide and the corresponding duty to act arise at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, if a state has available to it means likely to have a deterrent effect on those suspected of preparing genocide or reasonably suspected of harbouring specific intent, it is under a duty to make such use of those means as the circumstances permit, end quote. And that is what South Africa has done by making this application. In cases such as Lagrande, Avena, Jadav, this court has exercised its power to order provisional measures, having regard to the impact not only of provisional measures on the state's parties to a case, but also to the impact on the individuals directly affected and their rights. It has issued orders to restrain states from killing individuals in a manner alleged to violate international law. And that is what South Africa is requesting, after more than 23,000 individuals have already been killed in the siege and bombardment of Gaza, the overwhelming majority of them innocent men, women, and children. The court also issues orders to safeguard the integrity of its proceedings and the efficacy of its final ruling. In the Bosnia genocide case, for example, you ordered that the parties, quote, not take any action and ensure that no action is taken which may aggravate or extend the existing dispute over the prevention or punishment of the crime of genocide, or render it more difficult of solution, end quote. Without such non-aggravation orders, there is a real risk that a respondent will rush to complete its unlawful conduct before the court's final ruling, thus rendering the ruling and the court an irrelevance. Well, South Africa has kept its application in this case within the scope of the Convention. First, some will ask why South Africa does not seek any court order against Hamas. This case concerns Israel's actions in Gaza, which is territory that 3 weeks ago in Resolution 2720, the UN Security Council stressed is, quote, an integral part of the territory occupied in 1967, end quote, by Israel. As the court will understand, Hamas is not a state and cannot be a party to the Genocide Convention and cannot be a party to these proceedings. There are other bodies and processes that can address the questions of steps to be taken in respect of past atrocities and against other actors, and they are no doubt considering what they should do. But as a matter of law, under the Convention, South Africa cannot request an order from this court against Hamas. Secondly, South Africa understands that not all violence constitutes genocide. Acts of ethnic cleansing, collective punishment, the targeting of civilians, attacks on hospitals and other war crimes are all unlawful. But they do not always violate the Genocide Convention. Genocide requires an intent to destroy, in whole or in part, a national, ethnical, racial or religious group. But the fact that what Israel is doing in Gaza may also constitute war crimes or crimes against humanity is no defence and no bar to a charge of genocide. South Africa has set out its request for relief in paragraph 111 of its application and its request for provisional measures in paragraph 144. The reasoning behind the requests is pragmatic. The first two paragraphs of the provisional measures request call for the suspension of Israel's military operations in and against Gaza. Israel's continuing operation in Gaza since the 7th of October attack is the focus of this case. Minister Lamola has recalled the fact that South Africa has condemned the 7th of October attack. Israel says that Palestine and Palestinians are not its target and that its aim is to destroy Hamas. But months of continuous bombing, flattening entire residential blocks and cutting off food and water and electricity and communications to an entire population cannot credibly be argued to be a manhunt for members of Hamas.